Hi, I'm Darcel Lobo of Dow Law Firm, and here we're talking to you today about common mistakes that I see with estate planning. Before we get into details, I am in Washington State, and so I'm only licensed to help individuals in Washington State. If you're outside of Washington State, thank you so much for watching. I appreciate you being here, but unfortunately, my office will not be able to help you. Hopefully, someone in your state or local county or city can help you with your estate planning. But whatever state you're in, let's talk about some common estate planning mistakes that I've seen to maybe hopefully help you or help someone else to not make these mistakes. So let's just get right into it. So the first one that we're going to talk about is naming a minor as a beneficiary. I've talked about this in other videos, but a lot of times maybe parents or grandparents will leave funds to a minor in a will. If someone is under the age of 18, in Washington State again, they are not competent to inherit anything under state law. So you cannot just leave funds outright to a minor, whether it's in your will, listed as a beneficiary on a bank account, on a life insurance policy. You should not be naming a minor directly to receive those funds because in Washington State, they are not competent to inherit those funds. So what's going to happen, depending on the amount, a court is going to open a guardianship for that minor to hold those funds. But it's actually a little bit more complicated than that because a guardianship is quite expensive because you have an attorney for the guardianship. The court is appointing a guardian ad litem to review the files. I mean, there's a lot that goes into it without getting into the details of it. But with just, some proper estate planning, that whole process can be avoided, right? So in Washington State, we really have two main options that I utilize for providing for minors. One is the Uniform Transfer to Minors Act, commonly called a UTMA account, where you're naming someone in your will or in your trust as the custodian of the funds for the minor. So let's say you wanted to leave something to your 4-year-old child, you would name someone as a custodian of those funds, and that person, those funds will be held in a custodial account for that minor, and then the custodian that you've named will be the one kind of in charge of those funds, but they be held until the minor reached at least the age of majority, which is 18. But I commonly recommend to my clients that they don't leave a lump sum to a minor when they reach 18, especially depending on how much we're talking about. Unfortunately, sometimes at 18, an individual is not ready to receive a large lump sum inheritance. So maybe age 21, 22, maybe 24, 25, maybe a little bit later before those funds are released from the UTMA account to the minor. Now, your other option is a trust for minors. We can do this in your will or in your revocable living trust, where we create a trust for that minor, or if you have multiple minors to provide for, we create a trust, for all minors that outlines when those funds are to be received by the minor. And with doing a trust, we can break it up into different increments over a longer period of time. And so depending on how much the minor is going to receive, maybe you want to break it up in halves or maybe in thirds. A lot of my clients, breaking it up into thirds at ages 25, 30, and 35 is very popular with a lot of my clients. And up until those points and in between those points of time, funds can be paid for the individual's, health and well-being and for education, things like that. But there's no lump sums being paid to that individual, to that minor, until they reach the ages that you specified, whether that's 25, 30, and 35 in thirds. If you want to do a large, just one lump sum at the age of 20, whatever, you can pretty much do whatever you want to do with the trust. But there has to be an end date. There has to be a point at which the funds are, depleted and given out to the individual who would no longer be a minor at that point. So at some point it has to end, but it gives you a little bit more control over how and when those funds are used. Okay, so that's mistake number one that we see in our office. Mistake number two that we see is not properly executing a will or a codicil. So I understand that for a lot of individuals, estate planning can be expensive. It can be an additional expense. We try to keep our fees reasonable. We share our fees for our estate planning on our website. So I'll link it down below, and you can see on our website what the cost is for a will package, for a revocable living trust package. But even though estate planning can be expensive for some, doing it incorrectly is a lot more expensive. Okay? If the will is not drafted properly, not signed properly, not witnessed properly, there are requirements here in Washington State for a will to be a valid will. If you don't have a valid will, then the court can defer to just what state law provides. And that might not be what you want the distribution to actually be. And so we want to ensure that your will is executed properly. If you go online and find a will template, or you use some kind of document drafting service, you want to ensure that you are having it executed properly with the witnesses, with the proper attestation clause. Like, there's some requirements and formalities to a will that can get missed if you're doing it yourself. So I understand the cost-saving measure of doing it yourself, but just keep in mind that if it's done incorrectly, it's going to cost significantly more for your family, for your friends, for your loved ones, whoever may inherit from that will if it's not done correctly. All right. Number 3 is not keeping records about your assets and just really your financial affairs. So because not many times, but on more than one occasion, on a number of occasions, after someone's passed, maybe the family will come to me, and maybe there's a will, right? There's a will that says who receives what, but the family comes to me and they say, we don't know what the person owned. We have no idea where they banked. We have no idea if they had life insurance. We have no idea if there were retirement benefits. We don't know. And they come to me looking for these answers. And I don't know either. Okay? So there's no central database for assets. There is for debts, right? I can order a credit report to see what debts there were, but there's no asset report that we can pull to find out what all the assets are. So what do we do in that scenario? We're having to go through mail, go through all the files in the decedent's home. We're going through old tax returns. And that's really a lot of work for your family or your executor to have to do, to try and piece these pieces together of the puzzle about what your estate even includes. So when we do estate plans here, for all of our estate plans that we prepare, whether it's wills or trusts, we prepare binders for our clients. And in the back of the binder, there's forms for the client to fill out to list where do they bank, who does their taxes, are there life insurance policies? Are there retirement policies? What's your email login? What is your phone passcode? Trying to get access with the passcode to someone's phone, or trying to get email login credentials for someone after they've passed away is pretty impossible to do. And so if you put this information together and include it with your will, with your trust, and it's not part of the will, it's just supplemental documents that we include in the binder that you fill out. So your family has that information. They know where to go. And so that all the assets that you worked so hard to acquire during your lifetime aren't for nothing. Because if your family doesn't know about it, doesn't know it exists, then they're not going to be able to claim it, right? So we want to ensure that when you do your will, when you do your trust, make sure along with those documents that you have information about your assets so your family knows where to go. And again, if you're inclined to do so, phone passcodes, email logins. Now, if you do all this, it's going to help your loved ones tremendously in your will. However, if you put these we do binders for our clients, so you can't lose your binder, right? You can't lose all these documents because it's such sensitive information, right? So you want to ensure you keep it somewhere that's safe and secure. If it's at home, whether that's in your safe at home, if it's at a safe deposit box at a bank, wherever you keep it, make sure the important people in your estate plan, your executor, your power of attorney, that they know where these documents are, that they know that they exist, and that they also have access to them. So make sure they have the safe combo, or make sure that they're named on a safe deposit box. Make sure that they have access. Okay. And then the fourth area of estate planning mistakes that we see pretty commonly, unfortunately, is waiting too long to do your estate planning. Procrastinating to get it done, putting it off, kicking that can down the road, and then suddenly it's needed. A power of attorney is needed for you, for whatever reason, right? Maybe it's short term, like a hospitalization, an accident. Maybe it's something long term, like dementia or Alzheimer's. And when it's time that you need an estate plan, it is too late to prepare your estate plan. The time to prepare your estate plan is before you need it. So if right now you feel like, oh, I don't need a will, I don't need a trust, I don't need a power of attorney, I'm too young, I'm healthy, I need to do that later on in life. No, the time to do it is now, when you don't need it. Because if it's needed and you don't have it, it's too late. I cannot do a power of attorney for someone who doesn't have competency to understand what a power of attorney is. I can't do a will if you don't have competency to understand what the will says, right? So when you need it, it's too late to prepare it. Okay, it needs to be done before you need it. Even if you don't think you need one now, it can be a very simple will. It does not need to be a complicated will. It does not need to be a complex process for you. If, your distributions and who you named, if it's simple, great. But prepare a simple will for you so that there's a plan in place. So that if a power of attorney is needed, if that will is needed, you've already taken care of it and it's already handled. Okay, so when someone comes to me, it's, kind of sad to have to tell someone that I can't do your will, and to have to explain to them that, there's an issue of your competency and being able to understand this document. That's a very rough conversation to have with someone, especially if there is a loss of competency, right? For them to understand why I'm saying that we cannot do a will or why I'm saying that we can't do a power of attorney. So please, if you think you don't need it yet, if you think that, you'll do it later on in life, I highly suggest that you reconsider and that you do this now and take care of this for your family and loved ones. Okay, so those are kind of the few areas where we see estate planning mistakes and kind of some suggestions from me on how to resolve those mistakes, right? So now that you have this information, you can then in turn take that and make sure your estate plan is in place, make sure you don't have minors named, make sure your will is executed properly if you did do it yourself or did it with a program, make sure it's done correctly, making sure you have all your asset information gathered for your family and loved ones in one place so that they know where to go. If you need help with your estate plan and if you're in Washington State, I would be happy to help you. Again, I'm Darcel Lobo. I own Dow Law Firm. I'll have our website linked below as dowlawfirm.com, or you can text us or call us at 206-408-8158, and we'd be happy to help you. Thank you.